This program is presented by University of California Television. Like what you learn? Visit our website or follow us on Facebook and Twitter to keep up with the latest UCTV programs.
Over the last 2 decades, no criminal defense attorney in America has had a more profound impact on advancing the rights of the convicted than has Barry Scheck. In 1992, when forensic DNA testing was still in its infancy, Mr. Scheck, along with his colleague Peter Neufeld, founded the Innocence Project, which has since figured prominently in the release of hundreds of prison inmates. Mr. Scheck also teaches at the Cardozo School of Law in New York, and in addition to co-authoring a book about Innocence Project cases, I am told that he has written at least one screenplay that has yet to be made into a motion picture. Barry Scheck, welcome to Legally Speaking.
Welcome. Thank you.
You're known throughout the world as this brilliant attorney whose work has resulted in the release of so many people who've been convicted of crimes that they had absolutely nothing to do with. Yet at the same time, when people hear the name Barry Scheck, they think to themselves, oh yeah, that's the guy who back in 1995, in essence, helped O.J. Simpson get away with murder. That's what they think, that's the rap. So I guess I'm wondering whether you feel that there's any tension between those two elements of your reputation.
Well, when you say tension, I mean, maybe in some people's minds, but there's been a clear, intellectually consistent path. When Peter Neufeld and I were brought in by the defense team in the O.J. Simpson case, it was at the time before even a DNA test had been done on that case, and they were just analyzing all kinds of biological evidence. And by the end of the trial, the prosecutors, particularly Woody Clark, who subsequently became a judge, unfortunately he's passed, and Rock Harmon, the other prosecutor, they agreed, essentially, that the way that the Los Angeles Police Department Crime Lab had handled the crime scene evidence was all wrong.
Yeah. I guess, when I talk about, tension, what I'm talking about is, as a criminal defense lawyer, your relationship to the truth. And as an Innocence Project lawyer, it seems to me your stock and trade is the truth. I mean, you're proving beyond a reasonable doubt that these people have not committed the crimes that they were convicted of.
Oh, not only that.
Now, in the O.J. case,
we find that people who really committed the crimes.
Yeah. Now, in the O.J. case, what you did brilliantly was discredit the prosecution's case, and there was an 8-day cross-examination that you did. The witness on the stand was an LAPD criminologist named Dennis Fung.
Yes.
I understand that was just a brilliant cross-examination, but you would acknowledge, wouldn't you, that there's a gap between, on the one hand, discrediting an expert witness, and on the other hand, proving your client factually innocent, right? I mean, they're two different things, aren't they?
They can be.
Yeah.
On the other hand, they can be, one of the same. I guess the point I'm really making to you is that the critique of the evidence in the O.J. Simpson case was correct. I mean, you don't pick up blood stains, put them wet into a plastic bag, and then put them in a hot truck. And what the criminalist at the LAPD lab, when he took O.J.'s blood and he opened up a purple top tube and had an aerosol spray with all this high molecular weight DNA going everywhere, and he actually said, I don't think I necessarily changed my gloves. So then he touches all the evidence from the crime scene, including the blood drops, which had already been degraded because of the way they were mishandled. I mean, that is a disaster.
Yeah.
There is nobody that thinks that any of that was done correctly.
Yeah.
And as a consequence, we didn't take any unfair shots. Now, I'm not even saying that defense lawyers are prohibited from making arguments which they may not necessarily believe themselves in terms of discrediting witnesses.
Yeah.
But it just so happened in these cases, every scientific argument we made, every critique we made of these criminalists, not only did we believe, but I think the community has accepted as being correct.
So when people ask you, do you think O.J. Simpson was factually innocent, what do you say to them?
But my first answer is the answer that you would expect from any lawyer, and that is to say I have a duty of loyalty to my client, and this client, I think all the defense lawyers would agree, told us from the beginning to the end that he was innocent and insisted on it. And the jury found a reasonable doubt, that he was not guilty beyond a reasonable doubt. And I think there was more than a factual basis to support that verdict. Mm-hmm. So, you know, more than that, and all the books on it that have been written, some of which unfortunately have a lot of the defense files, which, believe me, I think never should have been disclosed under those circumstances.
Yeah, let me
give a very good description of all the things that happened in that trial.
Let me say one of those books. Jeffrey Toobin wrote a book called The Run of His Life back in 1996. And in that book, he characterized you as the best lawyer and certainly the hardest working lawyer.
That was the best lawyer. That was the title of the chapter.
That's right. That's exactly right.
And I didn't know Jeffrey.
That's right. And he characterized you as the hardest working lawyer on O.J.'s much vaunted defense team. But he also said this. He said, quote, Scheck's goal epitomized the nihilistic function of a defense lawyer to establish that the mountain of forensic evidence against his client means nothing. To be sure, many of his explanations were fanciful and some were silly, and they were in part contradictory, positing a police department that was both totally inept and brilliantly sinister. But Scheck's passion and skill made his theories real for the jury, and for that reason, he is as much as any other person in that courtroom responsible for the verdict that came out of it.
Yeah, but he also said at the beginning of the chapter that that if you followed all the arguments, they were intellectually consistent and they made sense. When he's saying it's fanciful, I mean, that's because Jeffrey has a view of the evidence that Mr. Simpson is guilty and that some things, you know, he finds implausible as explanations in terms of how certain things got into certain places. But in terms of the science and the cross-contamination of DNA and how it could have happened in the crime laboratory in particular, you know, he recognizes that those were intellectually consistent. So, you know, why is this such a big deal? You must know the truth.
We're going to move on. But
no, I mean, I don't mind.
Yeah.
This case was a disaster for the American criminal justice system. Let's get that straight. Yes, and in ways that may surprise you. First of all, the coverage of legal proceedings, I think, were irreparably damaged. Now we have the era of Nancy Grace.
Yes.
And tabloid TV in the coverage of high-profile cases. And my friend Steve Brill, who had invented Court TV, believe me, because I was one of the original commentators, we used to have essentially requirements of what lawyers should know before they get on television to comment on a case. They have to understand the evidence in days that preceded it. They had to understand what the law is. They had to keep their comments within certain normal limits. It wasn't just to make the most incendiary comment that you could and develop kind of a trash TV.
Gladiatorial.
Oh, it's just, you know, I mean, trials in America, from the Scopes monkey trial before and after, have always served a form of public entertainment.
Yeah.
But that's not what you really wanted when you started televising trials. You wanted people to learn about the system. And Jerry Ullman and I were just reminiscing the other night. We saw each other in Los Angeles and had dinner, and we were remembering how at the very beginning, people like us who teach law were saying, "Oh, this will be a wonderful educational opportunity," and it didn't turn out that way at all.
Yeah.
And it was quite unfortunate, because there was a hope that you could use television to look at legal proceedings, and people would learn a lot about it. It didn't turn out that way from the Simpson case. It really became about ratings. It became about trials as entertainment, infotainment, and the racial consequences, I think, really set us back. So in so many ways, it was a disaster for the system. Ironically, the one good silver lining out of that case is that it absolutely transformed the way that criminalists and forensic scientists dealt with crime scene evidence, and it ushered in a new DNA era in full swing.
So since 1992, when you started the Innocence Project, my understanding is that your efforts and the efforts of other Innocence Project lawyers have resulted in the release of something like 300.
There are 312 people that, as we sit here today, that have been exonerated with post-conviction DNA testing. Mm-hmm. Our project, the Innocence Project, based in New York, has been responsible for, either as attorney of record or assisting in over 186, 87, I'm not sure of the exact number. There are now 51 projects in a network of what we call the Innocence Network. Mm-hmm. And those projects have certainly done a number of DNA cases and non-DNA cases. Our Innocence Project is actually, by accident, essentially exonerated 7 people in non-DNA cases. The prosecutors themselves have been able to exonerate people with DNA evidence. So altogether, 312, but in close to 45, 46% of those cases, the real perpetrator has been identified. And out of the 312 cases, I think you can say with confidence that those people are actually innocent. Now, there's another list that's put together by our colleagues Sam Gross at the University of Michigan Law School, a great journalist, Maurice Posley, and Rob Warden, another great journalist at the Center for Wrongful Convictions in Chicago at Northwestern Law School. It's called the Registry of Exonerations. And if you go online, you'll see that since 1989, which we date as the beginning of the DNA innocence era, mm-hmm. There have been over 1,500 cases, DNA and non-DNA, where people were convicted, their convictions were vacated based on new evidence of innocence. They either were acquitted on a retrial, pardoned by a governor, prosecutor decided not to pursue the charges. So that's an instrumental definition of an exoneration. As the authors of the registry will tell you, not every one of those people will they vouch are actually innocent, but most of them probably are.
When we're talking about exonerations, say over the last 20 years, how many of those exonerations have come from death row?
Well, that's an interesting question. We've had 19 post-conviction DNA exonerations, but those are people on death row. Mm-hmm. Quite a number of our cases were people that were death eligible, or they would have been death penalty cases, but they were in non-death penalty states.
Who's come the closest to actually getting executed before you were able to exonerate?
Well, in our case, I think the closest we had was Ron Williamson, who John Grisham wrote about memorably in the book The Innocent Man. We wrote about him in Actual Innocence, but he and his co-defendant Dennis Fritz, who thankfully was not charged with capital murder, but Ron came within 5 days of execution.
5 days. I've heard like one case in which it was like a matter of hours.
Well, there have been a few like that, you know, a day or 2 hours.
Yeah.
But you asked me about a DNA exoneration. I think, Ron, we initially called actual innocence, 5 days to execution, and other dispatches from the wrongly convicted. So, but Grisham's book is a wonderful book, and John is just a fantastic writer, and you know, a really admirable person in every way, both as a public figure and just as an individual. He's a mensch.
Yeah.
But the book is his only nonfiction book, I believe, and it's terrific. Everybody should read a John Grisham book. Read that one.
Okay.
But that will certainly show you, dear readers, that the risk of executing innocent people is a real one. And so much of what we've learned about this is that it is beyond regulation. Now, probably the most prominent case that the Innocence Project has been working on now for quite a number of years involves somebody who wasn't lucky at all, Cameron Todd Willingham, who was executed in Texas by Governor Rick Perry. And we have already demonstrated, I think, to any reasonable person's satisfaction, and the satisfaction of the Forensic Science Commission in Texas, which was a group we helped set up in the first instance, but that the arson evidence that was used to convict Willingham, who was he was convicted and sentenced to death for killing his own children. And the theory is that he
burned his own house down.
Burned his house down. 3 children were in it one morning, and he went around the house, and in different areas he would splash accelerant. But there was no accelerant recovered from those areas. And what happened is that the fire marshals, experts, went to these different areas, and they said, oh, there's a V, or there's alligatoring, or there's spider glass, or there's scouring, or there's burning under furniture. And these are signs that an accelerant was used, but the fire was so intense it burnt up the whole accelerant. But those are the different areas where the accelerant was spread. And the expert even went on the stand and he goes, I look at the fire, and the fire doesn't lie. It talks to me. And the fire is telling me that the person who started it wanted the children to die. I mean, it's really extraordinary testimony. Now it's been demonstrated by every expert that's looked at it.
It's been completely discredited.
Completely discredited. Yeah. There was no accelerant in these places.
So you've been trying to get a posthumous exoneration, pardon.
Posthumous pardon, because we found out something else. And here's what people have to understand about Willingham. Not only has the science been demonstrated as junk, but at the time of the trial, the prosecutor had a problem because the defendant's wife, who had left earlier that morning, was saying, I think he couldn't have possibly have done this. There were problems in our marriage, but Todd would never do this to the children.
This is Stacy?
Stacy. And what happened is that all of a sudden this jailhouse snitch, Johnny Webb, who was in prison at the time awaiting trial on a robbery in the first degree, claimed that Willingham one day just said to him, you know, I killed my children, but I did it. I burnt down the house because I wanted to protect my wife. She beat up one of the children, or the children, before she left for work, and I didn't want anybody to blame her. Now, the autopsies of the children don't show any of that. So it was kind of crazy on its face. But we've now demonstrated, and we just found this evidence, that Webb, at the time of the trial, was asked, in return for pleading, you pled guilty to robbery 1, yes. What did you get? 15 years. What's the earliest you can get out? 3 years, 9 months. In return for that plea, did you get any promise, any benefit from me, the prosecutor? No. Is there, you know, there's nothing I can do for you, John Jackson asks Johnny Webb. He says, yes. Well, the reason why this is so important is that on the eve of Willingham's execution, his cousin helped the defense lawyer find a leading arson expert who gave an affidavit saying, this is all junk science. And the prosecutor then, from Navarro County, answered by saying, well, even if that's true, it's 10 years too late, but even if it's true, you still have the confession to Johnny Webb, and that's legally sufficient to uphold the conviction and the execution. And technically speaking, you know, that's true. And we have now spoken to that prosecutor who wrote those papers, and he did not know what we have just found. And what we have just found is in the Johnny Webb file. Yeah. We found that he was brought back in 1996. He was resentenced to a robbery in the second degree so he could get out early, which was an illegal sentence. They did in what they call in Latin nunc pro tunctit, from a robbery 1 to a robbery 2. But the only basis for nunc pro tunking a sentence in Texas of that kind from a robbery 1 to a robbery 2 is that it was a clerical error, that when he originally pled guilty, he was really pleading to a robbery 2, not a robbery 1. And there's no evidence in the record to suggest that that was the case. And then written in the prosecutor's file for Webb is the statement this was, you know, robbery 2 and based on cooperation or co-op in the Willingham
Which,
case.
of course, wasn't disclosed at the time.
No, not only was it disclosed, not disclosed, but the prosecutor who filed those last-minute papers has told us that if he had known about that statement in the file, that there was a deal, it's what lawyers called Giglio or Giulio era. It's a Supreme Court case. That's, every prosecutor knows you have to disclose that, and if you disclose that, then the whole house of cards would have fallen right then in 2004. We would have known that the jailhouse snitch's testimony was not true, and that the forensic evidence was junk, and I have a lot of confidence that the whole case would have fallen apart and that Willingham would be with us right now. But that didn't happen. And so we are still working on this, and we think that that is misconduct. And as I said to John Schwartz of the New York Times, I can't see any innocent explanation for this behavior, and it is really beyond regulation.
The folks who fight tooth and nail to prevent clearly innocent people from being released, maybe even being released from death row, do you ever view any of those folks as just simply evil?
No. I think that, you know, we've learned a lot about cognitive science. And I really mean that. I think that, you know, from the point of view of cognitive psychology, and there's a neuroscience basis for a lot of this, you know, we know how people get into certain belief systems, and then they begin to, you know, they have confirmation bias, selection bias, expectation bias. It's very, very powerful. I've been teaching law for over 34 years. I see when my students become prosecutors. I see when they become defense lawyers.
You can tell that on the first day of class?
No, I see what happens to them. Well, what we find by the first year of class is that we assign people, you argue this side of the case, you argue that side of the case, and we give people sides that they would never think before they entered law school they could possibly defend. And then they get into the role, and they, in an adversary system, they start making the arguments from both different points of view, and then soon they're believing it, right? And they start viewing all the evidence from those different perspectives. Now that serves a good function in an adversary system, a dialectical search for the truth. There are different ways that one can go about fact-finding. There's a lot to be said for certain inquisitorial processes, as it's called, as well as for the adversary system, which I believe in. But what we do know about cognitive science and just the way people view evidence is that you can be biased, and it's very, very hard to de-bias people. I'll give you a very simple example that's relevant to this discussion. Our colleague E.T.L. Dror, Dr. E.T.L. Dror, is a great, great cognitive scientist. So he did this great example. There's a very famous case involving a lawyer in Oregon named Brandon Mayfield, who his fingerprint was wrongfully identified by the FBI from a whole list of fingerprints as having been on this plastic material in the bombs that blew up the trains in Madrid. The FBI said, there's a 15-point fingerprint match to Mayfield. And the only reason his prints were in the system is that he was in the United States military. So they picked him up on a material witness order. He was a lawyer in Oregon. And of course, he had married a Muslim woman. He had converted to being a Muslim. And so they go, oh my God, look, obviously it's him. And I spoke to the federal defender, then got a court-appointed fingerprint expert who looked at it and said, my God, it's Mayfield's print, right? And he's the defense expert. But the Spanish authorities were always saying, no, 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 that's not his print. We see discrepancies. The FBI said, no, that's an artifact. Every time a print goes down, this is true, and you look at a latent and it's a different surface, there can be distortions. And what you're calling a discrepancy, we call a distortion. And then finally, the Spanish authorities found a real member of Al-Qaeda, and they matched the print to this individual, and everybody became convinced, oh my God, it wasn't Mayfield. There was enormous cognitive bias in sticking to the judgment even after you made it, right?
Right.
So what Dror did is that he went out and he got a group of very, very experienced expert fingerprint examiners from the United Kingdom. And he and his partner, Dr. Charlton, they gave them a series of cases, and they said, this is the Brandon Mayfield case. And so everybody took a look at the prints, and they thought it was the Mayfield case. And all of a sudden, they began finding exclusions, right? Well, in fact, he didn't give them the Mayfield prints. He gave them prints from their own cases where they made matches. And so many of them, I think it was 3 out of 5, renounced their own prior matches in cases where people, everybody believed were guilty and they were true matches, just by biasing them and telling them it was the Mayfield case. He's then gone on to do this by telling fingerprint examiners, in this case, we have a false confession. In this case, we have an absolute alibi, and he biases results. Okay. He's gone on to do this with forensic anthropologists. I mean, in other words,
but when we're talking,
you can bias people.
But when we're talking about DNA, is there
DNA too? DNA testing, there's a lot of interpretation, unfortunately, when you're dealing with what they call low copy DNA, low template DNA. You know, when DNA now is tests are now done, you get these little spikes that look like an electrocardiograph or something, and there's a room for interpretation as to whether you're seeing something that's a real allele or a real genetic variant, or it's what they call stochastic fluctuation. It's an artifact, right? And people can disagree about it. So they've done experiments where they bias the DNA examiner with domain irrelevant information, as it's called, and you'll find that you can bias the way they interpret even DNA results. Now,
so, yeah.
The point is that what you ought to do with both DNA examination, and you can do it with fingerprint examiners as well, is that you have blind readings. In other words, when the DNA examiner looks at those spikes, they have to make an interpretation, not knowing who's, not looking at the samples from, let's say, the defendant or the victim or somebody else, until they really have to for purposes of doing an analysis. So they'll score the crime scene evidence a certain way, and then they'll look at the other stuff, and they call that sequential unmasking. Right? So they only get potential biasing information that is relevant to the examination later, okay? But also in other kinds of assays where you're called upon to make interpretations that's in part subjective, it should be done blind. That's what science dictates. Right. And you make your readings without biasing domain irrelevant information.
Right.
And most investigations, unfortunately, of all kinds are not conducted that way.
Well, let's talk about, you know, in terms of, say, level of certainty. Let's talk about, and this is a case that you talk about in your book, the Ronald Cotton case. This was a guy who was accused of raping a woman. The woman's name was Jennifer Thompson. And she identified Cotton, and she said she was absolutely certain that this was the guy who he was a stranger who broke into her apartment and raped her one night, and she remained certain until the DNA test was done, which showed apparently that Cotton was not the guy.
And identified the real perpetrator, ultimately Bobby Poole.
Okay, so I guess the first question is, did the DNA evidence show beyond a reasonable doubt that Cotton was innocent?
It sure did.
Okay, I mean, so there was no room for error there.
Well, I mean, but when we say there's no room for error, look what happened. And by the way, there's a wonderful book that Ronald Cotton wrote with Jennifer Thompson called Picking Cotton. Along with a great PBS, well, it's a great book.
Yeah.
And you have to see the two of them together because they've become great friends.
Yes.
Since the exoneration. And in the second trial, as Jennifer will tell you, they actually had Bobby Poole, the real perpetrator, there, because the great defense lawyer Richard Rosen and others had figured out that there was this other individual named Bobby Poole who had committed similar crimes in the same neighborhood. And then not only did the DNA exonerate Ronald Cotton, but it identified Bobby Poole, who had committed other similar crimes. And, you know, you could see the resemblance, and so ultimately, and he was convicted, obviously, of that crime. So I think you can say with a high degree of certainty that Ronald Cotton is innocent.
Right, because number one, the DNA didn't match him, and number two, the DNA matched this other guy.
Yeah, who you know, had committed similar crimes of that type.
Right. Now, you mentioned that Jennifer Thompson, became friends with Ronald Cotton. I mean, this is an extraordinary story. I mean, when she found out that she had made a mistake, that mistake meant that this guy Cotton spent 11 years in his life in prison for a crime he didn't commit. So how did she process that information? I mean, did she go through some stages of grief and acceptance before getting to the point where she could become friends with this guy?
Yes, she did, and she's really one of my heroes. Both of them are. And that is a remarkably transparent and moving process, spiritual process, and it's a great book. There was also a documentary called What Jennifer Saw. And what happened is that actually there was a documentarian for PBS named Ben Loderman. When we sent Ben down to North Carolina and suggested that he look at this case, and then he did this documentary where, you know, she describes the whole process of what it felt like to be sexually assaulted, how she was looking at the face of her attacker, and she's a very, very smart person, and she was going to remember it, and the whole process of how she came to learn, unfortunately, that the DNA had exonerated him, and now we've gone back and looked at that whole process of the identification procedures, and there's been a tremendous amount of work done by psychologists, scientists on eyewitness identification, and there are best practices in place that probably could have avoided this particular era involving having double-blind administration of photo arrays or lineups, and telling the witness, when you look at the photographs, if you don't see the person that you think did this, don't worry, the investigation will continue. It's just as important that you tell us the person isn't there as you make an identification, and that it all be documented, and they take confidence statements from witnesses.
In that situation, the power of suggestion is huge.
Enormous. It's huge.
And
we've learned a lot about this from experimental psychologists, and National Academy is coming out with a report on that soon. But we have had the New Jersey Supreme Court in the Henderson case, the Oregon Supreme Court in the Lawson case, have now come out with a whole series of scientific reforms that ought to be followed in assessing this evidence. The International Association of the Chiefs of Police and many jurisdictions in this country have adopted these best practices that will not eliminate, but they will certainly cut down on not just the number of wrongful identifications, but will cut down on the number of filler picks.
Yeah.
That is, witnesses picking people who we know are not the assailant, and that kind of burns the witness and impedes the investigation. So we're sure that these best practices, again, will not only prevent or certainly reduce the number of innocent people wrongly identified, but they will also enhance the capability of law enforcement to capture the right person.
Generally speaking, we know, do we not, that prison time is much harder for the innocent than it is for the guilty, that with the innocent there's a sense of rage and indignation that's so much more difficult to cope with. So I'm wondering if you understand how people who are in that situation, year in and year out, maybe decade after decade, are able to hold on to their sanity.
Well, I think I'm all admiration. I am stunned and humbled by the witness that our clients who have been exonerated for crimes they didn't commit. I just, as a spiritual matter, I find them incredibly admirable and courageous and amazing people. That does not answer the question that you really pose, like how many people have we not found who just went crazy? I mean, I've spoken to Kevin Green was a United States Marine. He did, I think, we wrote about him in Actual Innocence in one of our last chapters. Wrongly convicted for assaulting his wife. He did 17 years. I remember him talking about wanting to jump off a tier in San Quentin prison. He came very, very close to killing himself in doing that. How many people have we lost that just went crazy or wound up putting themselves in situations where they were killed? I don't know.
I mean, there was a guy that was just written about. I believe his name was Glenn Ford.
Yes, Glenn
Ford. Spent 30 years in prison for a crime that clearly he did not commit.
Yeah, I was just talking to his lawyer, as a matter of fact,
how can you be in that situation for 30 years and not go absolutely crazy?
Take a California example. This past week I was talking with Cash Register. That's his real name. It's K-A-S-H, Register, in Los Angeles. He did 34 years for a crime he didn't commit. 34 years.
So
how do people survive that?
Do you understand? Yeah, how people can survive that?
I think we have to understand that as a spiritual matter. And one of the things you find unites all of these individuals is that when they're first imprisoned for crimes they didn't commit, they're in a rage, as you can well expect.
Sure.
But there comes a point a few years in where they begin to realize that if they're enraged all the time, it'll kill them. So they find a kind of transcendence where they can transcend the anger. Sometimes this is misinterpreted. When the exonerated get out of prison after 10, 20, some instances 30 years in jail, people are amazed. They're so calm. They're so forgiving. They have this kind of spiritual transcendence that people pick up on. It doesn't mean they aren't bitter, and it doesn't mean they don't have grievances. My Lord, sure they do. But there is this unique kind of transcendence that they achieve. Otherwise, it would have eaten them alive.
So you find that the people who you've exonerated, you find that they all share that in common?
Yes.
In order to survive, they kind of all have to come to that.
They do come to a place, almost without exception, where they get beyond extraordinary, consuming anger and bitterness, and they are more forgiving of what happened and some of the people involved in the process than any reasonable person would expect. And what I found extraordinary are all these people that go before parole boards, and they know they can get out 5, 10 years earlier if they'll just admit that they're guilty. and show remorse so they can be let out. And again and again and again, people from ordinary circumstance with not a lot to prepare them for this extraordinary step show the moral courage to say, no, I can't say that I did this when I didn't. And they wind up spending all this time in jail. Cash Register in Los Angeles, who did 34 years, he was telling me just the other day, he went in front of the parole board 11 times. And 11 times he said to them, I didn't do this. And I know I could get out earlier, but I can't say I did something that I didn't do.
But how
because
common
that would
is that?
destroy your identity.
Yeah.
How common is it?
Yeah, how common?
It's extremely common
Really?
among the wrongfully convicted. This
Really?
is more common than not. And
I'm not
it's
sure
people
I
of
could
all
do that
kinds.
in that situation. I'm in prison for 10 years. I've got a shot to get out. I mean, could
Any
you
rat-
say? Could
no. I mean, as I sit here now, I can't imagine
Yes.
not doing it. But when I see it through the eyes of these individuals, I begin to understand it. Because if you're in 10 years before this, right, and you're innocent, it is such a strong part of your identity. It's
Yeah.
like negating yourself. It's like saying, what has kept me going all these years, the knowledge that I did not commit this horrible crime, that everybody thinks I did. If I admit that, I am destroying myself. There's nothing I can do to respect myself after I do that.
You've been talking about identity. Let me ask a couple questions about your identity.
Okay.
Over the years that you've been doing this work, you've become, for lack of a better word, famous. I know of 2 movies that have been made in which you were portrayed by a couple actors. There was a movie.
Peter Gallagher.
Yeah, Peter
Conviction.
Gallagher. It was a movie about an Innocence Project trial. Peter Gallagher played
It's
you.
a great movie,
and
Conviction.
Bruno
with
Kirby
Hillary.
played you in.
Well, that was an O.J. movie.
That was
but
an O.J.
you should go
movie.
see the
Yeah,
Conviction
yeah.
movie, much better.
So-
no, it's a terrific movie.
I saw that. Great movie.
Wasn't it good?
But what's
Hilary
it like?
Swank.
Yes, Hilary Swank
plays
yeah,
Betty Ann
yeah,
Waters,
yeah,
who
right.
talk about a heroine,
Right.
Who a high school dropout who went back to college and then law school to get her brother out of jail. Great performance by Hilary.
So what's
Sam
it like?
Rockwell playing her brother Kenny,
Yes.
and Peter Gallagher, who
Peter
played
Gallagher,
Gabe. He was great.
Well, I was going to ask, what's it like for you to be sitting in a movie? Well, I don't know if you saw it in a movie theater or not, or in front of your large screen TV.
My next door neighbor and dear friend Andy Karsh produced that movie. I had a lot to do with making that movie. It took
Okay.
11 years.
Okay, 11 years.
Took 11 years to
Wow.
get that movie made. Great script by Pam Gray, and our dear friend Tony Goldwyn directed it. Helped produce it. He's the president in Scandal now, but he's a brilliantly talented artist and can do so many things and a real supporter of our project and the movement. So I think it's a terrific movie. I think we were really hoping for that it could be Academy Award worthy. Came out unfortunately the same year as The Fighter and other movies about the same era, same kinds of people. I don't know, but I thought it was underrated. I'm very biased. I had a lot to do with making it. But,
my wife and I saw it a couple weeks ago on Netflix. I thought it was great.
Oh, it is great.
But what's it like for you to be watching someone else play you? Is that weird or what?
Well, I wasn't there when Peter read the lines, and he came in. He's just a great guy, and but it's a little different because. I had a lot to do with making that movie from the very, very beginning, from the interviews through the scripts, through
Were you there when they were shooting
casting.
it?
I was there on set.
Okay.
I even read some lines as myself when Hillary and her good friend are walking through a supermarket, and Betty Ann is talking to me on the telephone, but you see Peter Gallagher on a hot dog stand in the streets of New York talking on the phone, right? But in fact, when the lines are being read, I'm talking to Hillary for her reaction when she filmed it. So I didn't have the funny feelings that you might. I had more of a.
So you were in on it from the get-go.
Yeah. very in on it.
I mean, it's a great story. This woman, Betty Ann Waters. Betty Ann Waters. I think she just had a high school education. Actually, had a GED. Her brother went to prison for a murder he didn't commit. She was sure he didn't do it. She decided to go to college and go to law school to get him out.
Right.
And she did.
Yeah.
And with the help, with your help and the
pressure, the pressure, broke up her marriage.
Yeah.
She's raising 2 kids.
Right.
It's just an unbelievable story.
But the sad thing was, and this wasn't covered in the movie because, as I read, it was too much of a downer to it be in the movie, is that the guy, after he was released, died a year later?
He had an accident. He fell off a wall heading home from a Chinese restaurant and fractured his skull and died.
And that was after spending how long in prison? Like 10 years?
No, he did more than that. I think Kenny did close to 17, 18 years.
Wow.
And he did terrible time. He really had hepatitis. He was suicidal. It was really horrible. And they depict some of the problems that he faced mentally in the movie. But no, we tried a lot of different things with that. We had one ending written where in a hospital room, a true story about with him dying. Audiences hated that. We had even putting the what happened to everybody later
in print
at the end. There's some of that. If we say Kenny died, people hated it. And even
this was the antithesis of a Hollywood ending. There was just no way to incorporate it.
And then the worst part was, even if we put in for Kenny at the end, people would know he was dead, and they got upset leaving the movie theater. Otherwise, so we just got rid of it completely.
Was that a cop-out to do that, do you think?
I don't think it was a cop-out. I mean, the movie, I think it ends on actually a wonderful note at the house that they shared by the woods with the 2 of them.
Before you go, I do want to ask you about the U.S. Supreme Court's jurisprudence. As much as you've accomplished with respect to advancing the rights of the wrongfully convicted, your cause has not fared too well at the U.S. Supreme Court. And there are 2, I think, key cases to talk about. One is Herrera versus Collins, in which the High Court ruled in 1993 that a claim of actual innocence based on newly discovered evidence is not grounds for federal habeas relief.
Well,
have I summarized that correctly?
No. As a matter of fact, this is misunderstood.
Okay.
In Herrera v. Collins, a case went to the United States Supreme Court where the question was put to them, would just being actually innocent alone raise a federal constitutional claim, all right, in a writ of habeas corpus? And a plurality decision by Justice Rehnquist said, well, assuming arguendo that actual innocence would be a federal constitutional claim, Herrera is not innocent or did not make a sufficient showing. Justice Sandra Day O'Connor wrote a concurring opinion in which she said, are you kidding? It would be a constitutional disaster not to say that actual innocence would present a federal constitutional claim. And she made suggestions about what that standard would be. Justice White agreed with her. Justice Souter and Justice Blackmun dissented. And they said, I think there's enough evidence here to hold a hearing. Altogether, if you exclude Rehnquist, who didn't take a position one way or the other, Scalia and Thomas dissented, saying, we don't think there is such a constitutional claim, but even if there were such a case, don't worry, the clemency system would take care of it before it ever reached our court. In fact, there have been 6 votes on the United States Supreme Court for actual innocence as a federal constitutional claim. Herrera, right, forward. When Ruth Bader Ginsburg, you can see I follow this with some care, when Ruth Bader Ginsburg and John Roberts were brought before the Senate Judiciary Committee, they were asked about whether they thought actual innocence was a federal constitutional claim, and they said they thought it was. Sonia Sotomayor had already found it when she was sitting on the Second Circuit. And I don't think there's any doubt that Judge Kagan believes that as well. Judge Alito, when he was asked about it in his confirmation hearings, said he didn't think he could answer that question because it might arise in front of the court. But it did recently, and it did in the case of Troy Davis.
Yes.
And in the Troy Davis case, an original writ was brought to the United States Supreme Court after he had failed the regular route. And the Supreme Court remanded it for a hearing on the claim of actual innocence.
Right.
And by the way, I forgot to include Justice Stevens as supporting the right of actual innocence as a federal constitutional claim in the original Herrera decision. So that shows already.
Yeah, and when it was remanded, the lower court found that the new evidence was not compelling enough to reverse the verdict, and he was ultimately executed.
That's right, whatever that standard is, and I'm troubled by the way that evidence went in.
When the Supreme Court remanded, there was a dissent by Justice Scalia. And his words, they become, depending on your point of view, either famous or infamous, which he said, "The court has never held that the Constitution forbids the execution of a convicted defendant who has had a full and fair trial, but is later able to convince a habeas court that he is actually innocent." Now, it occurs to me that, an opinion can be reprehensible and yet technically correct. Is Scalia's dissent, does that fit that into that category, would you say?
No, I don't think so.
You don't think it's correct?
No, I don't think it's correct, and because
as reprehensible.
Well, what's correct? If you have 5 votes on the U.S. Supreme Court, I'll tell you what's correct. So some people have said, Justice Brennan, but the truth is, I think both. There are 6 votes to recognize actual innocence as a federal constitutional claim if the proper case gets there in the right posture, and I think that would be the correct decision. And the man on the street or woman on the street is going to have that reaction. I mean, nobody wants to believe that our system is so wacky that if you can actually prove after your trial that you're innocent, that such a conviction should stand under our system as a matter of due process or under the 8th Amendment, but certainly as a matter of due process. I think it's a clear violation. As to what that standard should be, I think it's going to be.
I mean, the real fundamental question is: can you legally execute a person who's clearly innocent, even if he or she has gotten a "quote-unquote" fair trial and exhausted all of his or her appeals?
I think that's absurd. And I think most people
think it's absurd. You think it's absurd to execute such a person?
Of course, it's absurd.
Yeah.
I think Justice O'Connor called it a constitutional obscenity. That may be the phrase. But that's clearly the case.
But what about the system's interest in finality? I mean, you describe that as wishful thinking, but certainly...
No, finality is a very important value, but what we've been able to do in these DNA cases, and you can find it in other cases, is that there are instances where you can get a better fact-finding process even 20 or 30 years later because of technological advances or certain unimpeachable evidence than you got at the time of the original trial. I mean, nobody doubts that it's much harder. Gosh, I live this every day, to get the best evidence possible 10, 20, 30 years later than at the time of the original trial. On the other hand, sometimes you do get, because of either technology or witnesses coming forward who wouldn't come forward before, or people didn't know about before, more reliable fact-finding years later. And that's really the issue. So nobody questions that finality is an important principle, but it can't be the end-all principle in a humane and decent legal system in a democracy. People just won't accept, with good reason, a system that would allow not just the execution, but the continued incarceration of an individual who's actually innocent. And I think even Justice Scalia would say, and Justice Thomas, that they're not claiming that. They're saying, oh, if we had some proof of actual innocence, some clemency board or governor would pardon them. So it's just their view.
So that's where the
system.
wishful thinking comes in.
Yes, I think it's wishful thinking to believe that such clemency boards can effectively do that job. They do have a fail-safe function in the system, but the truth is they're not very good at fact-finding. They're not set up to do fact-finding. Indeed, many of our post-conviction processes are not adequately designed to do fact-finding. And that's one of the reasons why in North Carolina there's a very good system. There's an institution that actually has subpoena power that can look at cases to make factual findings as whether somebody's actually innocent or not. Experiments have been going on in the United Kingdom where they have something called the Criminal Case Review Commission that can look at cases, which has been okay, but by no means perfect. Canada has a pretty good law in this area. And our view from the innocence movement is that it should be an international human right. That in any legal system, whether it's adversarial or inquisitorial, there has to be a mechanism in place where somebody can prove that they're actually innocent and get their conviction thrown out. That's a fundamental human right as far as I'm concerned and as far as our innocence movement is concerned. And I think that every legal system in the world should adopt that as a principle. And I think it would be a good thing if we had a formal decision to that effect from the United States Supreme Court. But I think the jurisprudence is clear that there are still 6 votes for that proposition. Even today, you can count them.
I'll let that be the final word. Barry Scheck, thank you so much for doing this program.
My
I really
pleasure.
appreciate it.